We are resumed, and I will introduce our fourth panel. Our witnesses have been asked to make an opening statement of 5 minutes each. This will be followed by questions from senators. With us from the Nova Scotia Human Rights Commission, we have Shauna Paris, who's chair. And from the Organization for the Prevention of Violence, we have Stephen Camp, Project Director, Hate Crime Center. I invite Ms. Paris to make her presentation, followed by Mr. Camp. Over to you.
Good afternoon, Madam Chair, and also honorable senators. Thank you for the opportunity to appear before you today. My name is Shauna Paris, and I bring greetings as the chair of the Nova Scotia Human Rights Commission. I'm honored to be a part of your study for Bill C-9 from both the human rights perspective, but also from a social legal perspective, and also as a sixth-generation Black Nova Scotian. I'm also a defense lawyer and a forensic and clinical social worker and an educator. So all of those perspectives I bring to my comments and remarks this afternoon. Established in 1967, the Nova Scotia Human Rights Commission is one of Canada's oldest human rights institutions. The Commission is an independent statutory body responsible for administering and also advancing the protections set out by the Nova Scotia Human Rights Act. The Commission's work places us in regular contact with individuals and communities experiencing racism, anti-Semitism, Islamophobia, anti-Black racism, anti-Indigenous discrimination, homophobia, transphobia, ableism, and other forms of hate and exclusion. We also work closely with public institutions, employers, educators, service providers, community organizations, and governments to address the systemic barriers and strengthen human rights protections in Nova Scotia. In 2023, Nova Scotia had the highest provincial hate crime rate in all of Canada. Hate harms individuals, families, communities, institutions, and people's sense of safety and belonging. Hate can silence people and keep them away from schools, places of worship, cultural spaces, community centers, workplaces, and public life. The urgency of this issue is reflected in the national data that we have in Canada now regarding hate. So I begin from this position. Canada must respond. My central submission today is that Bill C-9 must be understood not only as a criminal law bill, but also as a human rights, community safety, and implementation bill. In the short time I have, I wish to emphasize 3 points. First, hate must be understood as harm, not merely as an offensive expression. Hate does more than offend. It can intimidate, isolate, and exclude. And it can tell communities that they do not belong, that they are not safe, and that their presence in public spaces is conditional. From a trauma-informed and human rights perspective, this does matter. Hate affects how people move through the world. It affects whether children feel safe in schools. It affects whether communities feel safe gathering, worshiping, organizing, advocating, or simply existing in public. Hate is not abstract. It is experienced in the body, in the nervous system, in families, and across generations. Second, the law must be clear, precise, and charter conscious. The goal must be to target hate, intimidation, obstruction, and the willful promotion of hatred, not legitimate disagreement, religious discussions, academic debate, peaceful protest, political expression, or advocacy. Our charter, the federal charter statement for Bill C-9 recognizes that the bill engages several charter-protected freedoms, the freedom of expression, freedom of religion, and the freedom of peaceful assembly. The same charter statement does explain that the proposed definition of hatred focuses on the detestation and vilification and clarifies that hatred does not include a mere dislike, disdain, or offense or humiliation. That distinction is important. Communities harmed by hate need the protection. And thirdly, the implementation will determine whether this bill protects or actually reproduces harm. A law can be well-intended intentioned and still have disproportionate impacts if implementation is not carefully monitored. For Bill C-9 to be effective, police, Crown prosecutors, courts, judges, community institutions must be equipped to understand hate through a trauma-informed lens, culturally responsive lens, anti-racist lens, and a human rights lens. This is especially important because many communities do not report hate. We see that from the numbers. They may appear, they may fear they will not be believed. They may fear retaliation. They may fear the justice system itself. Others may have historical or current experiences of discrimination in public institutions. So I respectfully offer these recommendations, 3 recommendations. First, Parliament should ensure clear national guidance for police and Crown prosecutors on interpreting the application of Bill C-9. Second, implementation should include mandatory training on trauma-informed practice, anti-racism, cultural safety, religious literacy, disability, gender diversity, and lived realities of communities that are targeted by hate. And third, there should be public reporting and data collection to monitor the legislation's impact, including who's protected, who is charged, whose complaints are taken seriously, and whether racialized and marginalized communities experience improved safety. In closing, on behalf of myself and the Human Rights Commission of Nova Scotia, I urge this committee to treat Bill C-9 as more than a criminal code amendment. It is an opportunity to strengthen Canada's response to hate while also insisting on clarity, accountability, and respect for fundamental freedoms. The law must be strong enough to name hate, it must be precise enough to protect charter rights, and it must be accountable enough to ensure racialized, religious, Indigenous, Two-Spirit, LGBTQ, 1+, the disabled community, and all other marginalized communities to make sure that they're protected rather than further harmed. Honourable Senators, I respectfully submit that this committee should ensure that Bill C-9 maintains this careful balance. Thank you, and I welcome any questions you have for me.
Thank you, Ms. Paris. We'll now go to Mr. Camp.
Thank you, Honourable Chair, Honourable Senators and committee members, for the opportunity today to appear before you. My name is Stephen Camp, and I serve as the Program Director of the Hate Crime Centre at the Organization for the Prevention of Violence. I come before you with over 2 decades of experience dedicated to understanding, investigating, and addressing hate crime in Canada. As a former hate crime investigator, I currently research and develop policy, training, capacity-building strategies, and legislative reform. My perspective is grounded in evidence, jurisprudence, and the lived realities of communities who continue to experience hate-motivated harm. Bill C-9 represents a modernization of Canada's hate crime framework and positions Canada among the world's leading jurisdictions in this respect. It strengthens protections for the targeted communities while remaining grounded in the Charter and jurisprudence. Its provisions are aligned with core legal and democratic principles such as harm, retribution, proportionality, culpability, morality, symbolism, deterrence, and denunciation. This bill does not extend the state's reach beyond what the courts have already upheld. Rather, it clarifies and strengthens its coherence and enforceability regarding hate crime law. Bill C-9 establishes a new subsection of the current hate propaganda sections, the willful promotion of hatred when accompanied by the public display of certain prohibited symbols. This offense remains firmly confined to the long-standing high threshold articulated by the Supreme Court of Canada for the willful promotion of hatred offense and is grounded in decades of jurisprudence, interpreting and balancing the Charter protections for freedom of expression, opinion, and conscience. Moreover, the section acknowledges the significant emotional and psychological harm to targeted communities by willfully promoting hate by way of hate symbols, which diminish community charter rights and their right to self-actualize in a democracy. The bill further removes the religious expression defense. The courts have, regardless of the presence of the religious exemption, assessed the hate propaganda legislation through the lens of established jurisprudence and the Canadian Charter of Rights and Freedoms. A careful balancing of the rights to freedom of religion and expression against the statutory provisions on hate propaganda. The removal of this section, sometimes described as redundant, will not alter the necessary legal analysis with or without the religious defense. Courts will continue to apply rigorous scrutiny to ensure that the legal thresholds are satisfied vis-a-vis the Charter and established case law. Notably, Bill C-9 strengthens protections for legitimate religious doctrine and expression by clarifying legislative intent. The bill explicitly states that, for greater certainty, the communication of a statement does not incite or promote hatred solely because it discredits, humiliates, hurts, or offends, or, for greater certainty, nothing shall prohibit communicating statements on a matter of public interest, including an educational, religious, political, or scientific statement or discourse, if they do not willfully promote hatred. These statutory clarifications codify what Canadian courts have long extrapolated from Charter jurisprudence, that the threshold for criminal liability is narrow, it's contextual, and does not capture good faith religious teaching or doctrinal belief. One of the most important elements of Bill C-9 is the creation of a standalone hate crime offense. This renders Canada as a world leader in combating hate crime, and the benefits make it a force multiplier, enhancing democratic principles, freedom, safety, justice, and understanding. The benefits include an improved response to public safety, a recognition of hate crimes' harm and its affront to the Charter of Rights and Freedoms, and the understanding that the government takes this dehumanizing, destabilizing, and coercive crime type seriously. Naming the harm matters. Operationally, the provision will improve police response, provide a national definition of hate crime for the first time in Canadian history, increase reliable and accurate data collection, and increase public safety strategies at the local, provincial, and federal levels. The invitation and obstruction section of the Criminal Code is not new in Canada. Bill C-9 adds subsections to the existing Section 423 and focuses on intentional attempts to instill fear, deter access, undermine, or obstruct the ability of targeted communities to safely participate in public life, and provides guidance to the police and prosecution services. It does not restrict peaceful protests, advocacy, or dissent. These rights remain fully protected under the Charter. What it does prohibit is intentional, coercive conduct, behavior intended to intimidate people when they are attempting to enter their place of worship or place used by identifiable groups. For these reasons, I strongly support Bill C-9 and its 5 provisions. Thank you, and I look forward to your questions.
Great. Thank you both for your presentations. We'll now proceed to questions from senators, and we will begin with Senator Bernard, our Deputy Chair.
Thank you, Chair. Thank you both for your testimony today. It's been quite helpful. My first 2 questions are from Ms. Paris. You've talked about recommendations, and I'm wondering if you could elaborate more on recommendations for training that you were suggesting need to happen when this bill comes into force.
Yeah. And I thank you for your question, Senator. And I answer this from a lens of a lawyer for 31 years now. And I work with the law. But what I understand is that if, in fact, the application is not understood, how to apply the law, then it serves it doesn't serve the purpose for which, of course, it is established. Education is key. And I was fortunate enough to be able to hear a couple of the panels earlier today, and certainly with the police services, and they were right on point in terms of really the necessity of education and training for police services. But I'm also a social worker, so when I hear that, I also have to hear it from a cultural lens, a trauma-informed lens as well, because what does that mean? That certainly makes a difference, and especially if we're looking at sections of the new legislation where the interpretation is based on a criminal process intent. The mens reis. Well, I mean, when we're talking about hate, when we're talking about race and discrimination, how do we actually dig deep enough in understanding whether or not that truly is a hate crime? We were talking about symbols and signs today. Is it possible that an individual does not understand the significance of a certain symbol if they, have it on their car? So the possibility does exist. So I think going back to points that were made earlier today, education is key. That would be a recommendation for me, not only for the service providers, police services, definitely defense counsel, prosecutors, judges, but also the public legal education piece also has to be a part of it, and from a very, very broad lens. So that certainly would be one of the recommendations. And I could speak to other recommendations that came up as well in terms of just thinking about specialty courts. Why would we not have a specialty court? Nova Scotia has several specialty courts, and they seem to be working well. They don't operate on a daily basis, but, when you have a court where the judge is familiar with what the issues are and what the legislation is and how to apply it on a regular basis, as with the prosecutors as well as the defense team, then that also is an opportunity to certainly move these types of cases forward within our legal system. It appears to be supportive of it. Go ahead.
Thank you. Do I have time?
2 minutes.
Okay.
One and a half.
Would you see that training embedding an intersectional lens and a trauma-informed lens into the work, into that training?
Absolutely. Absolutely. Because we're looking at it from a human lens. I mean, we are complex as human beings. We come with basically our own experiences, things that will hold us with this particular legislation. It may exist, it may be there, but will people utilize it? So the intersection is basically to understand the application, who is using it, who needs to use it, and to adjust the training and education to that. It has to be with a very broad brush, because otherwise I see this legislation, it could be certain components of it can be both a shield and a sword. And how does that benefit the communities that we're hoping to be able to assist with this legislation?
Half minute.
So I'll pose the question to Mr. Camp, and on second round, we can get the response. Mr. Camp, I'd be interested in hearing more from you about the importance of naming the harm. You said naming the harm matters. I'd like to explore that a bit further in the context of this bill and how you see this bill being helpful in that process.
I'm happy to extend another minute, so please go ahead.
Oh, thank you.
Mm-hmm. International research and in a temporal sense as well for decades have focused on the incendiary, really extremely impactful negative harm and trauma that hate crime has on individuals, community, and society as a whole. And that research is clear through peer-reviewed articles and scholarly research for decades. Naming it's really important. It's symbolic for the communities to look at their government and their legislators as an entity that takes this type of harm quite seriously and are moving to protect the targeted vulnerable communities with robust legislation to protect the sacrosanct components of a functioning democracy. So I think that naming, like for example, the standalone hate crime section, I think is one of the most important sections there. For the first time in Canadian history, we're actually naming this particular crime type. When I teach community, I educate community members on hate crime. Every time I say to them, there's no standalone hate crime section in the criminal code. There's no charge section. They were gasped. There's a literal gasp in the room when that happens. So naming it's really important. And plus, there's a lot of benefits to having the hate crime section besides understanding the harm to community and our society, everything from robust data collection, a national hate crime definition. And when someone's researching homicides or child luring or sexual exploitation, one of the first things you can do is go into the criminal code and look at the case law and legislation, understand exactly what it is. For researchers, government, community organizations, police around the world, in Canada for decades, the definition of hate crime has been elusive and piecemeal. And it's very hard for a researcher to research hate crime when police services aren't able to capture the data. The last thing I want to say, too, is, and you may have heard this in the previous testimony today, the Uniform Crime Reporting Survey will not connect to a criminal code, a crime type, unless there's a section in the criminal code. So if I'm a police officer on the street and I'm putting my report in on a hate crime, if it's not codified in the criminal code, there's no connection to UCR 2.4, which is the Uniform Crime Reporting Survey. So we're not capturing data. And that's why you have 2019 GSS showing 223,000 hate crimes occurred in Canada that year, where police reported hate crime was under 2,000, which is an incredible disparity in numbers. So that codifying hate crime in the criminal code actually connects to a national database that's in existence right now. And for the first time in Canadian history, we're actually collecting hate crime data accurately with a national standard definition. And so all that's rolling into this as well, which I think is paramount for our democracy.
Thank you. We'll now go to Senator Ince, followed by Senator Arnott.
Thank you. Thank you both for presenting here. My question is for Ms. Hoyt. Human rights commissions often operate in the intersection of protection of vulnerable groups and safeguarding freedoms. In your view, does Bill C-9 strike the right balance between combating hate and protecting charter rights, or does it lean too far to the other side?
Thank you for your question. And again, it goes back to my earlier remarks, Senator Ince, in terms of there has to be a fine balance. I mean, the charter is our guiding document in all of this in this country, and those particular freedoms that, in fact, it covers. In looking at this legislation, and being mindful of my remarks, and now I sit here as chair of the Human Rights Commission, there are sections of the legislation. I think that basically there needs to be, again, I'm going to go back to there needs to be a clear understanding and a clear interpretation of the language of this legislation. And then also the actual implementation and application of the legislation, so that it does not compete with with our charter, of course. And there are, I'll leave it at that. Yeah.
Thank you.
Yeah.
We'll now go to Senator Arnott.
Thank you, Chair. Thank you, witnesses. These questions are for Mr. Camp. Sir, your experience and the evidence you give can help us bridge enforcement, prevention, radicalization, community intervention, and data. And so these questions are around data. What data gaps currently prevent Canadians from understanding hate crime accurately? What needs to be measured very specifically? And do you see Bill C-9 as helping to improve prevention rather than just focusing on punishment? And if so, how do you see that? And then if you were going to design the 3-year review measure to determine whether Bill C-9 is actually working, in other words, is it helping the communities that it's designed to help? How would you do that?
On the data collection component, right off, like I had just talked about, not having a national definition, it's really difficult to collect data at any level of democracy, academia, government, police, intelligence services. So this not having a proper definition is really problematic. The second thing is 2 databases that are really important to data collection. I just talked about the standalone hate crime section. When you have it in the criminal code, it's codified. It's then coded for UCR 2.4, the Uniform Crime Reporting Survey for Stats Canada. That'll automatically start to happen. So you have a national definition. You have police officers, with or without charge or suspects, putting the report in as a hate crime for the first time in Canadian history. So now you're collecting data. I highly would recommend, too, that there's some incentive for police agencies to have highly specialized, some sort of specialization within the agency. Hate crime and hate propaganda legislation and case law and investigations are highly complex, and they're not for the front line unless they have some oversight with them. So I would highly recommend, even for the smaller agencies that have only 100 to 200 people or 80 people. I was at Tabor's Police Service Last month, they had 28. But even if you have, you don't have to have a full unit all the time. You could have a coordinator or someone given that portfolio to at least verify the files and say this is a hate crime and move forward at that point. And then there's the integrated criminal court survey as well. So with a codified hate crime section, when the files start making their journey into prosecution services, right now, currently, the hate crime data is not collected inside prosecution services and through the criminal justice system once it leaves the hands of police. With it codified, you can now start to track prosecutions, convictions, sentencing, all that stuff comes into play, but without it, they can't do that as well. So data collection on that point is really important to see if the courts are handling hate crimes appropriately. In regards to prevention, there's deterrence and denunciation, first of all, symbolism of the immorality of hate crime in our society, which I think will be a preventative component as well. But we never forget within our organization the components of restorative justice programs. A lot of our programs, for example, and there's agencies in Canada that do this, work with people involved in radicalization to violent extremism, including hate crimes. And so part of the job is to prevent them from moving in that direction. With understanding what hate crime is, more organizations, including police and intelligence units and our national security people, will be able to move potential offenders into these programs to prevent them from radicalizing to violent crime, including hate crime. There's a public safety component to hate crime. It's on the continuum of violent extremism. Ideologies that spur people to move into hate crimes can also move them to spur into federal policing area into terrorism. So there's a fulsome understanding of that right across Canada. And so we see hate crime as one of the components of the VE world, violent extremism world, that we have to attend to and prevent these young, like our youth that are being radicalized and moving them off that pathway into violent extremism. I'm sorry, and there was a third.
The third one was really, if you're going to design a 3-year review to measure whether this is successful, what would it look like?
Yeah, well, the simple one, first of all, is every time a hate crime unit starts up, you go from 0 hate crimes in that jurisdiction to 70 overnight. So that's the first thing. And I always tell police chiefs when I speak to them, this is a good thing. If your agency is showing you're having hate crimes in your jurisdiction, that's probably a good thing, even though for us it's a bad thing, but it's a good thing because hate crimes are one of the most underreported crimes in Canada. To have them coming into police and reporting is great. So that's the first thing. But then you'd have evaluation surveys as well to the police services community, which is stuff that we do within our organization. So there's research to show that is your institutions in a democracy handling hate crime properly, and get evaluations from that. So you get that data and research and move forward with policy development to augment that component. But what really helps with that is the hate crime standalone section. Because then you actually will have as accurate as we can get inside the criminal justice system, but this is a big step to actually start collecting the data. If I want data on homicides or sexual assaults, I can go to Stats Canada and get it. It's going to be accurate, as accurate as I can get. Right now, for hate crime, it's you don't know what you're getting. So it's very difficult for all of us to do the work with the proper data collection. So with the standalone hate crime section, I think it's one of the most important pieces inside C-9. Hope that helps.
Thank you. We'll now go to Senator Arnold.
Thank you, Madam Chair. And yes, that helps a lot, actually. I don't think I fully comprehended what the barrier to collecting this data was. So thank you very much for that. And just on those 3 questions, did you have anything to add, Madam Paris, on the the data gaps or the prevention or the 3-year measure? Did you have anything you wanted to add?
No.
So, as a fellow Atlantic Canadian, I'm curious why you think Nova Scotia has these somewhat alarming rates. Do you have a theory?
Mm-hmm. I do, actually. You have to think about the composition of the population in Nova Scotia, and in particular in the HRM, we have, I think, 7 major universities there. And so that obviously brings new people into the country, international students in particular, and many of those stay. And then in addition to that, there was a change also in terms of the immigration law. And what we saw was a change I don't have any data on this, but anecdotally, as someone who's been in the city since 1974, you saw an immediate change in terms of the diversity. The population had changed and has changed quite dramatically, in fact, in the HRM area, and I can't speak to the rural communities. And so that's it. It's that whole adjustment to people that have been there for generations. Then questioning what is happening, how are these changes happening, and why are they happening so quickly? And I think that has been one of the major concerns. People are. I'll look at the cases through the Human Rights Commission, the types of cases that are coming through now at this point. And, we've got the enumerated grounds under the legislation, but you could take some of those enumerated grounds and fit them into, of course, this hate bill as well. And so I think that is one of the major concerns, is that adjustment has not really kept up. In fact, that seems to be it. People coming in, new Canadians, also coming from other parts of Canada as well, and we haven't provided the education, the public education around all of that, which is an absolute necessity.
Thank you for that. And I would completely agree with that assessment. And I think it could be applied to Moncton, St. John, and Fredericton as well in New Brunswick. And that education component, I think, is so incredibly important. And it feels like it comes at us in all of our studies right now. And I do think that Atlantic Canada is maybe a few decades behind the rest of Canada, particularly from welcoming so many different cultures to our communities. I liken it to like we were living under sort of a little bubble and everything was peaceful and utopic, and then boom,
And then all of a sudden,
all of it has happened so quickly. Could you speak a bit to the education and what you're doing specifically in your region?
Yes. So basically, we have a division with the Nova Scotia Human Rights Commission. There is a division around education and such that is offering information to the public in terms of understanding the different groups, the diversity that's happening in the community. And so that is specifically happening through the Human Rights Commission. And I'll be quite frank in terms of saying that it is not happening enough just based on perhaps the municipalities offering more public legal education around diversity and also around legislation, even in terms of the criminal code as it exists now and its application and, or let me say, lack thereof. Because what we know is that racism is happening in our societies, in our communities, certainly in Nova Scotia, and yet if you and our numbers were high in 2023, but I think that if it were more broadly advertised, made the public aware, then that would be key in terms of people coming forward. And I think there was some mention, just in terms of restorative processes and other forms of education. I think that is key. It's not always about going through the criminal justice system or the justice system. I think the universities, as I mentioned, we've got 7 major universities there, I think just, in Halifax, HRM alone, to get them on board. So what I'm leading to is more partnership in terms of this legislation. I think the broader that it is and who it connects with, I think is what will bring about the change that is necessary in terms of its application as well as the results that we're looking for, and even the types of data that will come forward at that point in time. I mean, all we need to do is look at the Supreme Court of Canada. How many cases have we had in this country over the years that are based on hate crimes? How far does the court actually take? How many courts of appeals across the country have actually been able to look at the legislation that exists, and we'll say the criminal code itself, and be able to say we've got jurisprudence around these laws, and in particular the codified parts of the criminal code now that speak to different aspects of hate. And it's very limited in this country, extremely.
Thank you. Thank you. We'll now move on to Senator Wells.
Great, thank you. My question is going to start with Mr. Camp. We've heard from some individuals and groups that they feel that the removal of what's been called the good faith defense will criminalize religious text or doctrine under C-9. I'm just wondering, first, if you agree with that or not, and then secondly, based on your longstanding experience as a police officer who specialized in hate crimes investigations, I'm wondering if you could also then walk us through what an analysis of the willful promotion of hatred would actually entail for a successful charge to be laid.
Sorry, the first question.
First question.
Yeah.
So yeah, thanks. I threw two big questions out there. So the conversation around the removal
Yes.
of the good faith defense, and if that will criminalize religious text or doctrine under C-9, which is connected to the willful promotion of hatred.
Yeah, so I've always looked at that defense that's built into the criminal code. But when Supreme Court judges, defense counsels, prosecution services, and police look at whether they have a charge under the willful promotion of hatred, in the context of a religious doctrine, the defense is not, that piece of legislation is not looked at. They analyze it through jurisprudence and the charter. So it's interesting. Sometimes I look at that section as sometimes redundant. It can stay or go. It doesn't really matter when the analysis is done. It's done through the charter, like vis-a-vis the charter and established case law. And jurisprudence. So it's at the end of the day, if defense counsels are, even if that defense wasn't in there, the defense counsels would bring it up anyway, with or without it, because it would be a robust defense, but it would be analyzed through the lens of the charter and established jurisprudence. So I look at that particular section of C-9, and it's in a legal analysis, some people look at that piece of legislation as a defense, as redundant, can stay or go, it won't really matter, kind of thing. So,
and then the second part.
Yeah, so when you're looking at, for example, the symbols law, one of the most important components of that is the willful promotion of hatred, and the voluminous case law on the hate propaganda sections is unreal. It's complex too, but if you're going to be moving forward with a prosecution and willful promotion of hatred, I mean, right off the get-go, you have to have 6 elements that have to be proven. That the communicating statements was in the public domain, that you're willfully, intentionally promoting, which is that word's been analyzed and through case law for years, hatred against an identified community. So there's 6 components right there, and each one of those components have to be established beyond a reasonable doubt. Right from the get-go of the police investigation, you can't proceed with charges unless you've got that RNPG, and then that's analyzed through the entire judicial file journey, all the way up to if it goes to the Supreme Court. So right off the get-go, that beyond a reasonable doubt is a high threshold in the first place, but there's 6 really strong elements that have to be proven throughout that particular file. That's a 319 sub 2 hate propaganda. If you're conjoining that to symbols, that's part of the analysis. So if you're looking at displaying of symbols in a public place, you still have to prove you were promoting hatred in a public place, communicating it beyond a reasonable doubt. So the 6 elements would have to be proven as well. So it's an enormous, arduous process that's established from hate crime investigators across Canada and the specialized units that have to be attended to. And the other thing too to remember is that with the file moving forward, there's supervisors and staff sergeants, just Crown Prosecution Services. You got to get AG consent, and you have to go beyond a reasonable doubt with all 6 elements of that particular section. The public incitement of hatred has 5 elements that have to be proven, and advocating genocide has 4, all have to be proven beyond a reasonable doubt as well.
So I think just then to underscore that this notion of a willful promotion of hatred is a very high bar to meet in terms of successful prosecution of any of the hate crimes charges, and it's in general an incidental or accidental action or display is not going to meet that threshold.
correct. The case law is clear on that. Recklessness wouldn't be caught under that domain. Willful blindness would be, if you kind of think it could promote hatred again in the community, but you didn't stop the willful promotion of hatred anyway, then it will be caught up. But recklessness or accidents cannot be caught up in that. You have to really, it's an incredible piece of legislation, and this is why we say to agencies, you should have a specialized person handle hate propaganda investigations, because it's highly complex, it's transnational, most of it's online. But the elements are extremely difficult to prove beyond a reasonable doubt. One of them that's not there, the whole file is gone, and the investigation is gone. So the threshold is extremely high. Yeah. Thank you.
Okay. Thank you so much. Mr. Kemp, I wanted to ask you a question because the practicality of your presentation is very much appreciated.
Thank you.
And I wanted to get your perspective on specialty courts as your co-witness talked about, and what that would look like, or whether or not you think it's a good idea.
Well, when that was said, I was like, she's right on the money.
Okay.
So yes, highly recommend it. And I kind of mentioned the complexity of these files that require a high level of acumen by our investigators and our prosecutors. So we right now, we do train prosecutors because a lot of general prosecution services don't understand and have a difficult time getting around the hate crime laws and the case law. So having a specialized prosecutional unit or person in a small jurisdiction that has that high level expertise is a necessity on the practical side. I've talked to many investigators in the hate crime realm over the decades, and if they have a high acumen and the file moves to general prosecutions, the file sometimes is lost because there's a lack of understanding. So I'm a big advocate for specialization, both at the prosecution level, but also at the police agency level as well, because of the complexity of specifically the hate propaganda files. But proving motivation is another component too. So if you have a hate crime, you have the act, you have the act that has to be proved, and you have the mens rea intent, but you also have to prove motivating factors, which is another burden on both the Crown and the hate crime and the police agency as well. So having a fulsome understanding of the indicia or indicators or evidence of hate motivation is really important, so you don't lose that evidence as well. Mm-hmm. And so that specialization both at the Crown level for all hate propaganda and hate crime charges and at the police agency is highly recommended. And the transnational nature of hate crime and hate propaganda and the connection to violent extremism at the federal policing level, a lot of it's online. And the practical understanding of gathering evidence transnational, at a transnational level, like out of jurisdiction, like getting data from internet service providers or social media platforms from on different continents is an important component of these investigative processes and prosecutional understanding, and having a higher acumen in that field is what you need. It's required.
Okay. I feel like I need to put myself on second round, but before I do that, could you, Ms. Paris, comment on whether or not specialty court could also include, I think you mentioned this, a restorative justice process, and how that could work with the setup of a specialty court?
Yeah, absolutely. And again, specialty courts are not about, condoning behavior or, letting people sort of off the hook. It's still holding people accountable. But it's, if I can say, sort of putting the, I'll use the language, the perpetrator through a process that is educating them, while also holding accountability, right? And so, I'm a social worker, so I believe, and I'm a clinician, I believe in rehabilitation. I believe that human beings are very complex, and we don't always know what we don't know, and even when it comes to our behaviors, and when we talk about hate and harm on all levels. And I could see where a process of restorative and a restorative approach would work well within the specialty court. I mean, Nova Scotia, we have the domestic violence court. And, you know, part of the referral piece is to actually send the individual, I'll say, use the language perpetrator, off to a programming, right? So that they're being educated in terms of understanding the harms that they've done. I mean, that's basically what a restorative justice process looks like in any event. And it would work, not in all cases, but in hopefully many cases, and again, you know, we'd have to collect data and stuff on that, but it would be beneficial. Not only beneficial in terms of the individual because we're educating people, but also beneficial in terms of the community as well.
I still have more time. So, Mr. Camp, we've heard from a number of different panels about the importance of education. Can you comment on that from the work that you do, whether or not you see it as something that could be useful in terms of prevention?
Yes. So we're currently involved heavily in Western Canada in regards to training law enforcement and the criminal justice system participants, including corrections and prosecution services. And what we're finding is that when we do a pre-survey, the average understanding of hate crime legislation and concepts is moderate to low, and then when we finish, it's really high. And so then what we're seeing is the development through the education of augmenting and capacity to be able to manage hate crime better within that agency. So we see a real benefit in the training and education, but then when we do community as well, because we educate the community on these same principles, we're seeing the same thing as well. And so training education on for both community and the criminal justice system sector, I think, is paramount for appropriate police response. And the research is saying that. Research shows quite clearly that vulnerable communities, targeted communities of hate and extremism, violent extremism, want a robust response from the persons charged with responding to it, including police. And when they're not getting that, there's a trust issue that just disintegrates. Police officers are attending scenes, not thinking this is so serious, because it's not a high-level crime, but for the victimized community, it's very serious, and it's a public safety issue because their whole community is being targeted. That lack of understanding by frontline and policing can evaporate or diminish that really important trusting relationship between community and our law enforcement institutions. So we teach them about the harm of hate crime, the trauma of hate crime as well, so they have a better understanding of the complexities of this particular crime type.
Thank you. Thank you very much. We'll now go to the second round. Starting with Senator Ince.
Thank you. Mr. Camp, this question's for you. Your work focuses on preventing radicalization and violence. Do you see Bill C-9's criminal law approach as effective in preventing hate-motivated violence, or does it come a little too late in the cycle?
It's never too late. I think it's an important component. I really do. One of the first things that I see in this bill, and I'm going to refer to the standalone hate crime section, is a quick identification of hate crime, and then you roll in the issues of training and education. I think that's really important for police services across Canada to understand this. So what you have is an immediate understanding and recognition of what the hate crime is, its connection to violent extremism, and an appropriate response either through RJ processes, offender intervention, or more coercive methods, like some people may have to be charged and move through the system. I think it's vital for prevention because of the legal concepts of harm, deterrence, and denunciation that are all rolling into that as well. Then you throw in proportionality and retribution, consequences and culpability. You have all that coming together for an appropriate response that all moves to preventing hate crime from happening. Plus, with the quicker identification of hate crime, there's a lot of individuals that are in that realm of you're not really sure what to do with them. The intervention programs are magnificent. With that quicker identification of someone in the hate crime realm because of the standalone hate crime section, you can easily move them into intervention programs from across Canada. And the costs are enormously different between a full-fledged investigation on a group that's committing hate crimes or into the national security realm versus an intervention program. Like you're looking at $250,000 for a full-fledged high-level investigation with all sorts of investigative techniques, and then you're moving into our intervention program, which is, so you're looking at $250,000 versus $15,000 kind of thing. So there's an economic benefit as well, and I think it's the right thing to do. So, so the C-9 helps establish early intervention points that aren't there right now because of the lack of definitions. And with definitions and legislation comes case law. Case law also guides for the guides for the past case law guides future interventions as well. So that's really important.
Okay.
I will now go to Senator Bernard.
Thank you, Chair. This question is for both witnesses. We've heard both sides of the arguments around the use of symbols in the bill. And so I'd like to know what your thoughts are. Should we be listing symbols? And if we are listing symbols, are there some that are missing?
Yeah, excuse me. Thank you for the question, Senator. I think to list symbols would be exclusionary. I think that really and truly the idea is to keep it broad. There are parts of this act that should be narrowed and read narrowly, but other components of it to be very broad because we don't want to miss anyone or a symbol. And symbols can change on a daily basis. It's very fluid depending on who the group is and or the symbol. So I would say that the language around the symbol should be kept broad, and that to me would be more inclusive than to have a list, because the list then becomes a checklist. Oh, no, didn't. And when the threshold is already high on the criminal prosecution side, then it may be more of a barrier than an access point.
So your suggestion would be to have no list.
That's right. Yeah.
Mr. Kemp?
And one thing about that particular section, what I think is prudent, is the conjoining the symbols to the willful promotion of hatred. I think that's an important safeguard. I think it's important to do that. So I want to say that. The symbols list, still grappling with that one. The list, the good thing about the list of terrorist entities is this issue becomes less of an issue, because it's not the list we have to concern about, is if the terrorist entities that are established in the criminal code, are they using symbols? So if I'm going to be saying, I'm going to talk about the terrorist entity component here, if I'm going to be saying this terrorist entity is now using this symbol, I have to prove that. So that way we don't have an established cemented list. As time evolves, certain groups that are cemented are going to use certain symbols, and if you can make that link, then you have a problem. Then you could have a charge, kind of thing. So that's what. So the list is able to evolve, and you're not having to update the list all the time. So I do like that component. Then there's the Harkencruz and the SS bolts as an actual established list, and the inclusion and exclusion component is an issue there, I think, and how many do you put in and how many do you put out, kind of thing, would be something we'd have to grapple with.
Thank you. Senator Wells.
Great. Thank you, Madam Chair. My question is for Mr. Camp. We'll start there. We've heard from some witnesses that the new laws proposed in C-9 are redundant and already exist within offenses in the Criminal Code of Canada. For example, let's bring up intimidation and obstruction and hate symbols. So my question is, do you feel the new offenses proposed in C-9 are appropriate and necessary?
They are appropriate. Criminal law is interesting. You can disaggregate, first of all, criminal law based on harm. So if you look at, for example, I'll use the analogy, the sexual offenses are broken down into dozens of different types of laws depending on the harm. It's done to either children, domestic violence, all that comes into play. So disaggregating criminal offenses or concepts into different categories is nothing new, and it's really, I think, important for our legislators to be able to do that and really focus on specific harms that are caused by specific offenses in a general category. When you look as well at the intimidation, obstruction section and the symbols, I don't think it's redundant. The symbols do have an immediate effect on our victimized communities. Everybody can see them from afar, and they are communicating a specific ideology of hate, so they're quite impactful. So I think it's important to disaggregate that for both the community and police, for that them to understand, but keep it conjoined to the willful promotion of hatred. And the intimidation and obstruction charge, that section's established under 423 already, and it has very good case law on that. I like the fact that it is very specific to a particular harm it's doing to society, where people or individuals or groups are targeting specific institutions that are focused on that identified community and oppressing them into, or coercing them into not going into their place, not coming out of their car, having to walk through sometimes gauntlets of people, or the car gets surrounded. That stuff is really important, and that intimidation or provoking fear is an important component. And I think that helps guide our criminal justice system agencies that are charged with this particular offense. It's more specific than the general intimidation offense that's in place right now. And it actually mirrors the Alberta Health Services one as well, which is actually a pretty good piece of legislation when it comes to the intimidation and obstruction component. So it does act as a very specific guide. Yeah.
Senator Ince, you're on the list. We have all of 2 minutes.
Okay. Ms. Paris, this is for you. Let me see. Civil liberties groups argue that the intimidation provision is overly broad and could capture lawful protest. From a human rights perspective, do you share those concerns, and how should the provision be narrowed, if at all?
Sorry, Senator, could you just repeat that? Yep.
Certainly. Civil liberties groups argue that the intimidation provision is overly broad and could capture lawful protest. From a human rights perspective, do you share those concerns, and how should the provision be narrowed, if at all?
Yeah, I do share those concerns in terms of what an understanding of thinking about peaceful or lawful protests would be, and who those entities would be, what groups, what cultures would be protesting. And depending on the lens of who is seeing the protest, it could be or couldn't be determined to be intimidation in some way. So what, in actual fact, what group is it? And we have to keep this in the context of we're in a country, and I'm just going to say it. We know racism exists, right? So basically, depending on who is enforcing. At the time, where they're at, what the protest is, then it could be misinterpreted as being intimidation as opposed to being lawful protest. And that is a concern. So I think that for some of the marginalized groups and cultures, various cultures, ethnic groups, and so on, that look at this legislation as it applies to them, may say that this is more of a, on that particular point, more of a shield as opposed to, more of a sword as opposed to a shield for them, right? Depending on, again, what the protests and such is. So, yeah.
Thank you so much.
That's the end of this panel. So on behalf of the committee, I would like to sincerely thank you both for taking the time to appear before us today. Your testimonies will be very helpful in our deliberations. We will now suspend for the next panel.